All right, Mr. Nopes.
Judge,
Have a seat, thank you. Yeah.
Bonnie. Well, we'll take that. Yeah, let me, I'm gonna take Mr. Talbot out of order, Judge. We got depot set for either December 4th or 6th. So if we could put this on December 30th, we'll hopefully get it in for a landing, but.
Well, if you can, we can move it up
That's the
too.
earliest we can get it, okay?
We can move it up to December 5th if you can too.
Yes,
Okay?
sir.
All right, December
Thank
30th.
It's now set for December 30th. Judge, then I've got out of custody Bonnie Holland. Judge, she's present. The state and I have agreed to continue this.
December 30th. Thank you.
J.C. Rycroft, Judge. J.C.'s present. Judge, the state and I have agreed to put him on for December 30th as well.
December 30th, Mr. Rycroft, thank you.
Appointment, okay? Call my office and set an appointment. Judge, I then have Aaron Zimmerman. He's present, Judge. The state and I have been talking on this case this past week as well as again today. We think we're going to have it resolved on December 30th. They just need to, I need to try to put my hands on a couple documents, and they need to look at it as well. So
Well, we can move it up to December 5th if you do. If
Yes,
you-
sir.
We'll set it for December 30th and you can move it up if you want to, okay?
Yes, sir. Thank you, Judge.
Mr. Powell?
Judge.
Good morning.
First case is Garrett King, case number 2024 CF 1943. We have this worked out. I was wondering if we could set it for like Thursday morning, or we could do a written plea as a misdemeanor now. Can we do a written plea?
Yeah,
since
just
it's-
do that. That'd be all right, just written plea.
Yeah, since it's reduced to a misdemeanor?
Yeah,
Okay. He was working out of town, and I didn't get.
just
a hold of-
have it, send it to me so I can deal with it Thursday.
Yes, sir.
November
I'll
7th.
get it to you tomorrow.
Okay.
Okay.
Get it to this, well, you ought to show up and hand it, you got to come to court. He don't have to if you got it written, just
But
bring,
I'll bring it Thursday morning?
yeah.
Okay, yes, sir.
Let the
Thank you.
state see that he signed it and all that kind of
Yes,
stuff.
sir. Thank you.
Okay?
For Your Honor is Jason Robert Miles, and three case numbers 21-1556, 21-1619, and 20-2056. I've been over the written plea with Mr. Miles extensively, and we have it to present. I'm going to have him sign it real quick, and then provide it to the state. And then if I could have the state sign it, I'd approach, Your Honor. I'm sorry.
Mr. Miles, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes, sir.
Thank you.
I wrote it in the other one. Let me write it in this. I'll change it first. Come and judge him.
Yeah. Thank you. State of Florida versus Jason Robert Miles, 21 CF 1556, 21 CF 1619, 20 CF 2056. Mr. Miles, you want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You're aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Powell did for you on your case?
Very.
Court finds the admission freely and voluntarily entered. Court accepts it. Sentenced to 11 months, 29 days, Okaloosa County Jail to complete the ECLC program. Court costs $515. Each is a concurrent sentence, and also the costs are to a civil lien, $100 VOP fee to each concurrent, and is it no credit for time served? Is that what I'm reading? No credit for time served?
Yes, sir, that's the deal with the program now.
Okay. No credit for time served on November 29th. Okaloosa, is that right?
11/29,
Oh, I got you.
on the 11/29, I'm sorry.
No deal on this, no deal for time served on this sentence. Okay, thank
Yes,
you.
sir.
All right. Thank you.
Thank you, Your Honor. All right, you got it to 11/29 and you're done.
Did I get a copy?
Yeah.
Oh, yeah,
Did I get a copy?
yeah, yeah, I can give you one.
All right, next.
Not signed, but that's everything.
Thank you, Jason.
Thank you, Bester.
Mr. Williams?
Yes, sir. Table here a little bit.
Any out you wanted to address before I start pulling?
No, these are all gonna go relatively quickly.
Right side.
Morning, Judge. Judge, this is gonna be a negotiated plea.
Okay.
It's for 6-month county jail with credit for time served since November 14th.
Mr. Hawkins, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God?
Oh, my God.
Thank you. You want to enter a plea to criminal mischief, a third-degree felony, correct? No contest plea?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir. I
Are
did,
you
sir.
aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Yes, sir, I was.
I mean, right now, are you
Oh,
under?
no, sir, no.
Okay. Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge guilty, sentence you to 9 months Okaloosa County Jail with credit for time served. Since November 14th, 2023. Civil lien for $2,684. Restitution to Philip Morris. Standard court costs, PD fees, cost of prosecution, all to a judgment. So, unless you're being held on something else, I guess you'll be getting out today, okay?
Yes, sir.
All right, thank you.
Thank you, sir.
Thank you, Judge.
Is this guy Keith Jackson? Okay.
That's correct, Judge. Do you mind if I date this for you, sir?
Sure.
I pulled the score sheet, but I'm fixing it.
Oh, okay. I'm just telling you to get it to him. Missed me a bit. Homicide. Committing the BOP, and what I have is 21 months with credit for time.
I have 31.5 miles.
Judge, we may still have a disconnect here.
That's the note I had after I spoke with you.
Did you do the,
I'm
get
doing
rid
it.
of the 24 and go with 12
I'm doing it, that's what I'm saying.
and then the,
Can they bring it back over in a second?
guy we're fussing over. Can we bring Mr. Jackson back towards the end of the docket and give her and I a chance to argue about this?
All right.
Steve?
Yeah,
Thank you.
we'll bring you back in a few minutes. Thank you.
Judge, this is Kenneth Jernigan. We've got a negotiated plea for 2 counts lesser.
Mr. Jernigan, can you hear me?
Yes, sir.
Would you raise your right hand to be sworn?
Judge, hang on a second.
Maybe your approach real quick?
Yeah, she's asked that we reset him for the 7th so the family can be here. I explained to him when I at the jail that might be a possibility.
All right, we'll set you for November 7th. Thank you.
We're going to bring you back on the 7th to do this, okay, so that she can notify the family.
You hadn't notified them?
No.
Okay.
Okay.
Thank you, Mr. President.
Excuse me?
The 7th?
7th, yes, sir, 2 days.
Williams, if you want to address Jones.
Judge, Robert King Jones, Mr. Jones won't be brought out, Judge. I spoke to him last night. He's sometimes an issue on transports, and we're going to continue his case.
December 30th.
Thank you, Judge.
Mr. Myers.
Judge, we have depositions set in this case for December 9th.
All right, December 30th.
Thank you, Judge. All right, Mr. Myers, I'll come out and see you again after the depots.
Mr. Moore.
Give me just a second with Mr. Moore, Judge.
Jeffrey Moore?
Judge, if we can put him back in the back, I'm going to try to get him. What we're looking at here is potentially a straight-up plea, and I just need to spend a little more time with him on it. He was out of jail until last night.
All right. Okay, thank you.
Thank you.
Mr. Norris.
Judge, Mr. Norris is the homicide case that we initially, I drafted and had scheduled a stand your ground motion, and then the court on its own motion continued him until 12:30. I think he was on for today because we were all anticipating he was going to go to trial this time. Mr. Norris, the court on its own motion continued your case until December 30th.
Yeah, we're having a judge change, and I don't want to make that type of decision to deny your motion or grant it, and then another judge try the case, because it could be totally different.
Yes, sir.
So it needs to have, you need to have a consistency, because this is stand your ground is could be dispositive, and a judge that actually would be trying the case needs to be the one to look at it, okay? Thank you. December
Yes, sir.
30th.
We've already reached out to the new judge to get your stand your ground scheduled, okay?
Thank you.
All right, no problem. Judge, I believe that's all that I had incarcerated.
All right, Ms. Rivers.
Yes, Your Honor, I have Tyler Oquain that's incarcerated.
Mr. Oquain, come on out. Stand away from the case, Judge.
Tyler Oquain, okay.
Your Honor, I think we've reached an agreement in this matter. I'm going to have him sign it. If the
All
court will
right.
give me a moment.
Yeah.
Yep, that kills everything.
And I can get to finish the program?
Yep,
That's
we're
my
going
main-
to we're going to have you enter the plea today and have you sentenced in December.
Okay.
Your Honor, he's before the court on 2 cases. That is going to be,
What's today's date?
today's the 4th.
Yes, ma'am.
21 CF 1972, 22 CF 523. Mr. Oquain is trying to complete the ECLC program, which will be in December. So we're asking that he enter the plea today, that the court accepts the plea agreement, do the plea colloquy, but not actually impose the sentence until your first day in December to make sure he can complete the ECLC program before.
State has no objection to that, Your Honor.
Thank you, ma'am.
All right. State of Florida versus Tyler Oquain, 21 CF 1972 and 22 CF 523. Mr. Oquain, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir, I do.
Okay. You want to enter a no contest plea to State's going to dismiss count 2 and 4 in 21 CF 1972, right?
Yes, sir.
Correct, Your Honor.
And then you're going to dismiss count 2 in 22 CF 523.
That is also correct, Your Honor.
So Mr. Oquain will be entering a no contest plea to one count of using computer to facilitate sex conduct of a child, 1 count of travel to meet a minor. So that's a 3rd-degree felony and a 2nd-degree felony. Third-degree felony of transmission of harmful material to a minor, correct?
That's correct, and that's in 1972.
In 1970, and then in 22 CF 523, one using a computer to solicit a minor misrepresenting age, a second-degree felony, correct? So you're going to enter a no contest plea to those charges. The state's going to dismiss those other counts.
That's correct, Your Honor.
Did you read and sign this plea and sentencing agreement form, sir?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, will impose a sentence on December 5th. Okay?
Thank you, Your Honor.
All right. All right, next.
Thank you for your patience, Your Honor. Judge, I have you in my custody, if I may.
All right.
Your Honor, first I have Mr. DeMarcus Abrams. Your Honor, Mr. Abrams is present and approaching 24 CF 204, 24 CF 520. Judge, we were hoping to get PTI out of this. The state, of course, in their discretion, has not granted that. They do have a probation offer. He does want to review the discovery with me one last time before making a final decision. We'd ask to continue this case.
December 30th?
That's perfect. Thank you, Judge.
All right.
Right. Do you need a card or anything? Next, Your Honor, I have Mr. Traquan Albergotti. I did just speak to Mr. Albergotti. He's perhaps in the hallway, but I do see Mr. Franklin just walked in. Your Honor, Tim Gibbs on behalf of Mr. Jad Franklin. Judge, this is 24 CF 1153. Your Honor, we were set for trial today. The state had extended a PTI offer to a misdemeanor battery. He has respectfully declined that offer from the state. We are still set for trial. We actually had also filed a sworn statement from the alleged victim wanting to drop the charges, so we're still set for trial.
Oh, it's mine. Your Honor, I would ask that the case be set for Thursday, the 7th.
That's just.
So are you asking for a continuance or something, or
I am asking for a continuance. I haven't been able to speak with the victim.
not go to trial this term? Is that what you're
No.
saying? Or do you still want it set November 7th?
We can put it even later than that.
We would object for the record to a continuance beyond the trial cycle, Judge.
Have you had a continuance yet?
I believe we have, Judge. Let me make sure, let me check what his speedy trial, because I don't think we've continued it past his speedy trial. Judge, his speedy trial without demand expires November 8th. We have continued this previously, appointed in June.
The
and
defense
continued-
has asked for continuances?
I'm sorry? We have, Judge, but the speedy trial 175 date is November 8th.
Well, you got 60 days, right? So,
If we demand it, correct.
yeah. So, December 30th, how about that?
Very well, Judge.
Then, and go to trial in
If I can
January?
get a hold, Your Honor, if I can get a hold of the victim and speak directly, because my notes show that, yeah, she did file a sworn statement. However, I have notes from my victim advocates that said the opposite. I need to verify that.
Yeah, I understand. So we can set it for December 5th also.
That's fine too if the court wants to do that. I just keep my objection for that.
Y'all make a decision.
Yes, Your
You
Honor.
know, 'cause
We should be
the
able
thing
by
is,
then.
is summoning 60 jurors.
Right.
You know, and all that we have to do, which I don't mind doing it. I like going to trial, but if the victim's going, I'm not going to show up, you know, or they don't, you know,
Exactly.
check it out. I understand.
Yes. Will
But
do.
the sooner we know, the better. We don't have to send out all those summonses to the jurors. So,
Very well, Judge.
okay. We'll set it for December 5th to see what happens.
Very well. Thank you, Judge.
Okay, thank you.
They'll get her a call. Yeah, give me a call and they're going to get in touch with her. Next, Your Honor, out of custody, I have Mr. Albergotti. Your Honor, Mr. Albergotti is present, 23 CF 2557. We have an agreement if I may approach.
Albergotti, would you please raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God. All right, you want to enter a no contest plea to charge of resisting arrest without violence and misuse of a 911 number, correct? And the state's going to dismiss the false imprisonment and the battery?
That's correct, Judge.
Is that correct?
That's correct, Judge. The incident date was November of 2023. The state has made multiple efforts to reach the victim in the case, and based on our lack of information from her and what little information we have from her, the state's not going forward on counts 1 and 4.
Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea? Are you happy with the work Mr. Gibbs did for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. On count 2 and 3, sentence you to time served concurrent, $50 cost prosecution, 220 court costs, $100 PD fee, all due within 180 days, or it goes to a judgment. Adjudicated guilty, both counts. Is that it?
That's it, Your Honor. Thank you.
All right. Don't wear shorts to court next time. I'll have to put you in jail, okay? Thank you.
Hopefully you don't have to come back to court, stay out of trouble. Next out of custody, Your Honor, I have Ms. Tricia Gatewood. Your Honor, Ms. Gatewood is present and approaching 23 CF 1533. We are asking for a continuance to 12:30. We're getting some more info to try to get it resolved.
That's without objection, Your Honor.
All right, 12:30. Thank you.
In the meantime, thanks. The only other person that I have on docket that is out of custody that I understand, Judge, is Mr. Azaria Bell. Azaria Bell. Azaria Bell. No response to the call.
All right, no bond capious.
Well, that's all I have out of custody. Thank you, Judge.
All right.
Through it.
Alan?
Your Honor, Tim Gibbs on behalf of James Allen, if I may have just a moment. Your Honor, we'll ask for a continuance. Did you want to continue it to a later date for that?
Yeah.
Judge, Mr. Allen, I believe, is going to be working on hiring a private attorney. We'd like to continue this to December 30th.
All right. Thank you, sir.
Good luck.
Arnett?
Your Honor, Tim Gibbs on behalf of Mr. Christopher Arnett. Judge, this is 24 CF 977, 24 CF 1243.
Okay.
Judge, we had given the state a counteroffer. The state is working to confirm with the alleged victim their acceptance of our counteroffer as well. We'd like to set this for Thursday to try to get that resolved.
All right, November 7th. Thank you, sir.
I'll see you then. I'll see you before then. Thank you, Judge.
Mr. Barr.
Your Honor, Tim Gibbs on behalf of Mr. Jack Barr. Judge, this is 23 CF 1016, 22 CF 1851. Yeah, no, we'll talk more about that. Your Honor, we had some more information and we have some more negotiation going on with the state. If this is set for trial, however, with the information that I've informed of Ms. Leone, we're going to have to continue this so we can discuss that. We'd ask for 12:30.
All right, December 30th.
She's not. All right, I'll get this.
Brooks.
Your Honor, Tim Gibbs on behalf of Mr. Dennis Brooks. Judge, this is 24 CF 1374, 23 CF 1000. I can have just a moment, Judge.
Just.
You're good. Judge, I'd like to pass Mr. Brooks for right now. We're getting some last minute things wrapped up.
All right.
He's got some decisions to make.
Okay.
Thank you, Your Honor.
Brooks is going to be coming back.
Your Honor, Tim Gibbs on behalf of Ms. Naomi Cantrell. Judge, this is 24 CF 525. Your Honor, we are working on getting her into saving grace. I have reached out to them. They are waiting for her application so they can screen her. We'll ask to continue this so we can get that done.
Without objection, Your Honor.
All right, December 30th.
And we'll move her up if we get a deal
right.
before that. We'll
Thank
be able to
you.
do that. We'll be able to move you up because they'll be quick to do saving.
Mr. Cooper.
Your Honor, Tim Gibbs on behalf of Mr. Randy Cooper. Judge, this is 24 CF 1832, and I believe he also just got a new case that will be appointed to. Judge, we did try to see if the state was going to be able to resolve the both cases. I did speak with them. They don't have an offer yet that covers both cases. We'll need discovery on the new case as well. We'll have to continue this case in order to in order to
All right,
get
well,
that
we can
resolved.
move it up to December 5th if you get it resolved.
Let's do that, Judge. I believe that's probably when his arraignment date is on the new case as
All
well.
right. So we'll say December 30th.
December 30th, Judge?
Yeah.
We'll move him up if we get a resolution,
All right, thank you.
because we got to get you to arraignment
Would
on
move
that.
to revoke bond in this case based on the new arrest in 24 CF 2513.
She's asking that the bond be revoked based on a new arrest. Is
Your
that-
Honor, I would ask to, I would actually ask to set this for this Thursday then, because I believe we were also working on doing a bond motion.
Well,
We can hear bond, state's motion, and our motion on Thursday morning if we've got time.
I'll revoke it and you can file a motion to reinstate.
Understood. Very well. Your Honor, Tim Gibbs on behalf of Mr. Joshua Douglas. Judge, this is 24 CF 1226, 24 CF 1678. Your Honor, we were working on resolving this today. However, the state does want to wait for the FDLE report on the controlled substances before making any additional offers or accepting any counters. So I suppose based on that, we'd have to continue, but otherwise, we were hoping to get it
Well, what
resolved.
we'll do is put December 30th, but move it up to December 5th if you got something
Absolutely.
worked out. Thank you.
Absolutely. I'll get you a copy. Yeah, I'll get you a copy. Mhm. Your Honor, Tim Gibbs on behalf of Mr. Jelante Durham. Judge, this is 23 CF 591. We are set for trial this cycle, Judge, but we did send a counteroffer over to the state. I believe the state needs to confirm their information and the counteroffer with the alleged victim in the case. Is that correct?
That's correct, Your Honor.
We have no objection to leaving it set for this Thursday morning for the state to have that opportunity.
If possible, Your Honor.
So is it set for trial?
It is, Judge.
This is set for trial. I'd requested the second week. We can still leave it set for trial. We're just negotiating. I need to contact the victim.
Well, how many days?
Excluding jury selection, I would say most 2 days,
I think that's appropriate as well.
right?
I agree with
All right.
that.
So the week of November 18th,
Yes, Your Honor.
2 days.
Yes, Your Honor.
So now what days is Miss Basso going? What days did you want?
This is Barrickman's case, but I believe Ms. Dudley was the 18th, correct? It's the 18th, Your Honor? I guess the 19th, right, ma'am?
18 and 19?
Yes, sir, that's what they had requested.
So we can do the following day, the 20th and 21st, Your Honor?
All right. Y'all give me these jury instructions, you know how we do.
Yes, yeah.
Okay. All right, we'll have a trial for you, Mr. Durham, unless you get it worked out. November 18th will be jury selection.
And we're not leaving it set for the 7th, just
Yeah,
in-
you can put it on the 7th.
We'll do it for status on the 7th if we
Yeah.
can.
Thank you, Your Honor.
Because we'll have a definitive answer by then, I think,
Yeah.
what the resolution is.
Okay, thank you.
So this Thursday, we'll have a definite answer on what the resolution looks like.
Fleming? Come on out, please.
Your Honor, Tim Gibbs on behalf of Mr. John Fleming, 23 CF 1634, 23 CF 1813, 22 CF 2205. Your Honor, I would like to pass him until later this morning. I have some new information the state provided that I want to go over with him to see if we can get it resolved.
Okay, thank you.
Thank you. Basically.
Truman?
Your Honor, Tim Gibbs on behalf of Mr. Adam Truman. Judge, this is 22 CF 2818. I don't have the benefit of a written plea, Judge, but we do have a resolution. The plan is for him to enter a plea today to the charges and put sentencing off until December 30th if possible. He is working on getting a video visit with his family. Both of his parents are very elderly and nearing the end of their lives.
Can you give me a plea form?
I can write a plea form up for you.
We'll
and
bring you
we'll
back
bring
in a
him
few
back,
minutes then.
and then we'll get you
Thank
set.
you.
All right. And that's the end of my out of custody, and I'll get on those. Thank you, Judge.
Mr. Williams?
Thank you, Judge.
Jackson.
Okay, that's all right, I've got folks that are out. Angela Herber. Judge, this was a PTI fail-out. I spoke with Ms. Claw. I don't know if Ms. Turner's had a chance to talk with her yet.
I have not, and I was a little, just a point of clarification, was this a PTI or was this a DPA?
You know, I called it as a PTI, but really it's more of a DPA. I think the paperwork was done up as a PTI, but Cody kept it, and I don't think it was ever sent over to probation.
So, Judge, I would,
But I'm not
I need to
100%.
follow up on this, and I need to, from what I understand from Mr. Williams, this may be one where Ms. Herber had actually completed the terms, but I have not received that verification, so I would just ask to,
Want to bring her back on November 7th?
yes, sir.
If you'll give us a moment, Your Honor, I can check and see if she was on.
We'll just bring her back November 7th.
All right,
Make
Judge.
sure. Okay, thank you.
Thank you.
All right, so come back on November 7th, okay? Hopefully, everybody will have an answer by then, okay? All right. Jason Howell. Judge, I was hoping we were going to have this resolved today, but it doesn't look like we do. I don't know if it was set with subpoenas or not. It's Ms. Leone's case.
I'm not
If it
sure,
was,
Your
I
Honor.
can go forward.
You'll
I had
want,
extended, I think, a misdemeanor offer. The one you sent me
Yeah,
by.
the reckless, I've talked with him about it. He's not willing to do that.
you got a prior record, prior criminal record?
Yes, he's charged with possession of a weapon by convicted felon.
Oh. And you've offered him one misdemeanor or two misdemeanors?
2 misdemeanors because he committed battery against his father, and so improper display, lesser included of count 1, and then misdemeanor battery, count 2.
And what was the sentence offered?
It was probation, maybe 2 years,
All right, so-
1129 consecutive.
Judge, our position is that he was acting in self-defense. His father is the one that brought the gun out.
I was in fear of my life.
23 CF is Jason Howell, right?
That's correct, Judge.
All right, we'll set him for trial. See what happens.
All right, Judge.
November, how about November 12th,
All right, Judge.
okay? How many days y'all want?
2 days, Your Honor, excluding jury selection. I apologize, including jury selection, 2 days.
So why don't we do the 12th and 13th?
That would be fine.
Your Honor, I'm
Oh, sorry.
Your Honor, if we may, there's going to be a case that Ms. Berkman we believe will set with Mr. Williams, the Kuntz case. And due to witness issues, she would be requesting those specific dates, otherwise the victim would be out of pocket.
12th, and she's just requesting the 12th and 13th?
Yes, sir. If we may.
Well, why don't we do his the 14th and 15th?
All right,
How about
Judge.
that?
Thank you, Judge.
Are we going to select
We'll select on Mondays,
On
come
Monday?
And have the
Actually,
jury.
the 12th be Tuesday. It's
Well-
a Veterans Day on
Oh,
Monday.
is that right?
Yes, sir. So I'm guessing both the juries will be on the 12th, if that's how the court wishes to do that.
So that's right, the 11th is Veterans Day, correct?
And
So
Ms. Bergman's
12.
case would go on the 13th, and then they would go the 14th.
Well, see, I don't have her case written down yet, so 13, so his would be probably the 15th and 16th, is that what it would be?
But if we keep the jury on one day, I would only need 1 day for trial.
You guys would be the 14th, then Sarah would be the 13th.
Yeah.
We'll pick the jury on the 12th and then try it on what day?
14?
So, yeah, he can do fingerprints, we can do them today, we can do them on jury selection, when you want to do them.
If he can do it today, I would ask Deputy Williams to take the fingerprints. And I know what you said, that can you please,
I'll get, but it's not full case prints, it's not.
They got full, but they got my full prints whenever I was arrested for.
Wait,
we need.
what dates?
No, that would be fine for my expert in Pensacola. I don't send it to FDLE.
Or do you want it on, or?
No, any card that you have, please.
Y'all finished? All right, we'll pick a jury for Mr. Howe on November 12th. And then the trial, Ms. Barrick needs the 14th and 15th on this other case, right?
She needs the 13th, please, Your Honor.
13th, 12th, and 13th, so we'll do him on the 14th and 15th, right?
Yes, please. Yes, sir. We appreciate that.
All right. And that's a 2-day trial, so if you can get it worked out, let me know as fast as possible so we don't summons these jurors, you know.
Yes, sir, Judge. I did send over yet another
Give me your jury
offer on
instructions,
Coons.
you know, like y'all need to do. Okay, we'll see what happens. Mr.
All right, Judge.
Mr. Howell, see what happens, okay?
Yes, sir. All right, thank you. I appreciate it.
Yeah, step over there and let him. Well,
Have a seat on the front bench, and then
Okay.
see if I have a more appropriate card.
all right, Judge Robert McDonald. Judge, this case is, Mr. McDonald filed a speedy demand. I spoke with the state about the case. Are you gonna drop this one, and then the other one, you know, there isn't a speedy trial on, or do you want to go, this is the one with Rebecca Feller?
I know.
What you want to do?
I'm not gonna go forward on that one, but the other one,
Okay.
yes.
So, do you have an announcement to make?
Announce the case number, please.
Hang on a second.
And this is Robert Michael McDonald?
Yes, sir.
Okay.
It would be your,
Yeah, that's, oh, I'm sorry, you got it?
I got it, 24 CF 2033. The state announces a null pros in the case per victim's request.
All right.
So this one has been dropped. You'll have to come back to court on the other one, though.
Okay, good.
All right, so same for December 30th?
Yes, Your Honor, the other case is good. for-
Okay, thank you. Hopefully you can get that resolved too.
And the other one's on for 12:30, Judge?
Yeah.
Okay.
Next court date is 12:30?
Yeah.
Okay. Frederick Moore.
All right, Frederick Dwayne Moore.
Ms. Bossa, we do not have an agreement on this case at this time.
And Your Honor, we just received on 11-1 an additional statement from the defense. We need time to look into that, so we're respectfully asking for a continuance.
All right, December 30th. Thank you, sir.
All right, Judge, I think the rest of mine are incarcerated. save the rest of mine. I'm sorry. I didn't know this today. Judge, we've reached a negotiated agreement on Mr. Jackson's case.
Mr. Jackson, would you please raise your right hand to be sworn?
I get
You
it.
you swear the testimony you give for this court's true, so help you God?
Yes, sir.
Thank you.
Judge, we've compromised on it.
Okay.
It'll be for 24 months instead of the 21 that I originally had.
Mr. Jackson, this is State of Florida versus Guy Keith Jackson, also known as Guy Keith Jackson, Jaxson. So in 22 CF 31882, you want to admit that you violated probation, and in 23 CF 2337, enter a no contest plea to the lesser charge of a misdemeanor battery, correct?
Sir.
All right. Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this admission and plea?
Sir.
Has anyone forced you or threatened you to enter this admission and plea?
Sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams did for you on your case?
Sir.
Court finds the plea is freely and voluntarily entered and admission is freely and voluntarily entered. Court accepts it. Judge you guilty, sentence you to 24 months Department of Corrections, concurrent with credit for all time served, all cases. And that's it, right?
Well, Judge, on the battery, you'll have to adjudicate or have to
Oh, yeah.
sentence him to a county jail
I'm
sentence.
sorry, yeah. I'll sentence you to time served in a county jail. And on the violation of probation, 24 months Department of Corrections, time served. Excuse me, credit for time served, 24 months.
He just gave you credit for time served.
Okay? Yes.
No, it doesn't.
All right, thank you.
Yeah, I've got, actually, one more in. Judge, while we're waiting, can we call up Mr. Kuntz's case?
All right. Jason Kuntz.
Judge, the state already announced what dates it's wanting, the 12th and 13th, I believe, if I understood correctly.
That's correct, Your Honor. This is the case that, from Ms. Barrickman, that we'd like to
Oh.
get tried that week.
Okay.
Judge, I did extend another offer over there, but Ms. Barrickman's out. I don't know if she's considered it or not. So if we can leave negotiations open, I think that might be best on this one occasion.
All right.
For this case, due to the nature of the charges, I believe Ms. Barrickman's requesting 60 jurors.
Okay.
I would concur with that, Judge.
So we pick a jury on the 12th, is that what you're saying?
Yes, sir.
And it's 2 days,
It's a one-day, I would believe,
1 day?
exclusive of jury selection.
And so we'll have this on the 13th?
Yes, sir.
Okay. So that means, so we have 4 trials. So the month of, I mean, the week of the 12th is just a 4-day week, right?
That's correct, Judge.
All right. All right, Mr. Kuntz, we'll have a trial for you and see what happens.
All right. Thank you, Judge. If anything changes, yeah, but otherwise, plan on being.
If y'all get this resolved, we can move them up to November 7th. Ms. Dudley, are you waiting on a case or?
Just wait to see how trials work out, Your Honor.
Okay.
Steve, who's this?
All right. There we go. All right, this is what you want to do. I need to get your signature there. Yeah, unless you got something else holding you in. Well, you might. I don't know, because I don't know what your bond status is on the other case. But, yeah, you would, you'll meet briefly with probation today, and they'll instruct you further. Okay. You'll sit down right over there with him, with them. I don't know what your bond is on the misdemeanor, is what I'm saying.
Is this Frederick Moore?
No, Judge, this is Jeffrey Moore.
Jeffrey Moore? Oh, Jeffrey Keith Moore. 24 CF 1357, 24 CF 1358. Mr. Moore, would you please raise your right hand to be sworn? You swear the testimony you give for us court's true, so help you God. Thank you. All right, Mr. Moore, you want to enter a no contest plea, the charge of possession of controlled substance, meth, a third-degree felony, and introduction contraband into a facility, a third-degree felony, correct? Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to make this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Mr. Williams has done for you? Thank you. Court finds the plea is freely and voluntarily entered. Court accepts it, withholds adjudication of guilt, sentences you to 2 years probation, concurrent on each case, standard court cost, cost of prosecution, PD fee, have a substance abuse evaluation, any recommended treatment, random UAs, waive cost of supervision. So withholding adjudication on both these, so you don't have a felony on these, okay?
Yes, sir.
Just do your probation and stay away from this. You're too smart to be doing this drugs and all this stuff, okay? Thank you.
Thank you, Judge.
All right.
Anybody else here that has a case before the judge?
That would be Felicia Riddle, 24 CF 1264. Ms. Riddle is present and approaching. The state has offered a DPA. She has signed the DPA.
Do I need to take a plea?
No, Your Honor, because it's going to be a DPA. It's number 40 on my docket, so it could be somewhere close on yours.
All right, Ms. Riddle, just do this terms on the deferred prosecution and charges to be dropped, I presume, correct?
Yes, sir. Thank you. That's correct. The state would just ask that Ms. Riddle get a receipt for the restitution so that we don't have to chase down the victim asking
All right.
about that, sir.
Pay it to the clerk of court.
And then get a receipt.
Okay, thank you.
That's all that I have. I only have a sentencing remaining.
Mr. Gibbs, Mr. Williams, anything else we need to do this morning for you?
Judge, I don't think so. it looks like I hit everybody.
We got witnesses on the Wesson
Yes, Your Honor.
case?
I do not have any witness.
You don't? All right, do you want to do that now?
Yes, Your Honor.
Okay.
That's fine.
Mr. Gibbs, you may want to do the plea.
Judge, I can still need some time to talk to you about Mr. Brooks and Mr. Fleming.
No, for Truman, I would say, you want to do the Truman?
Oh, Truman, we're ready. I'm sorry, yeah, we're ready on Truman.
All right.
I'm assuming you've got my email.
I did.
Perfect. Yes, we are ready on Mr. Truman.
I'm doing the score sheet based on the agreement.
Yeah. Because I figured for all the others, we'd do statutory max.
We're doing Truman real quick.
Find it. You got that.
I got that one to sign, yes. Thank you so much. Your Honor, we're back on the record for Mr. Adam Truman, 22 CF 2818. Judge, we have reached an agreement. Just going over, he's just going to sign his written plea. So, again. All right, that's what you'd like to do. Sign right there for me, please. Yes, sir. Yes, sir. Today's November 4th. If I may approach. Score sheet included as well. There's no objection to that score sheet, Judge.
State of Florida versus Adam Brock Truman, 22 CF 2818. Mr. Truman, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
Okay, you want to enter a plea to count one, a lesser included offense of trafficking in fentanyl, 14 to 28 grams, a second-degree felony, correct?
Should be a first-degree felony, Judge. I may have accidentally put the wrong
Well,
denotation.
I have, well, the way I'm looking at it, it says first-degree felony, but lesser included offense, 15-year. Isn't that a second-degree felony?
So the offer was for 15 years. It's still above guidelines, but it's still within the statutory maximums. The offer that the state made was for 15 years under the circumstances of this case and for Mr. Truman's circumstances. So it's still a first-degree felony. I believe it would be a level 8 offense instead of a level 9 offense. But the offer.
Oh,
was
I
for
see. So what the deal was 15 years.
Yes,
Okay.
reducing the allegation from trafficking in 28 grams to between 14 and 28
All right, I
grams.
got you. So a lesser included offense of trafficking in fentanyl, 14 to 28 grams instead of 28 or more. So you understand that? Okay. And count 2, possession of paraphernalia, a misdemeanor, first degree. Count 3 and 5, possession of controlled substance, a third-degree felony, and possession of controlled substance with intent to sell, a second-degree misdemeanor, felony, excuse me. And in count, wait a second. And count 4 is possession of a controlled substance with intent to sell, manufacture fentanyl. And 3 and 5 is possession of controlled substance, a third-degree felony. And count 5 is unlawful use of a two-way communication device. So count 1 is trafficking fentanyl, 14 to 28 grams. Count 2, possession of paraphernalia, first-degree misdemeanor. Count 3, possession of controlled substance, a third-degree felony. Count 4, possession of controlled substance, intent to sell, manufacture, second-degree felony. Count 5, unlawful use two-way communication device, a third-degree felony. Correct?
Correct, Your Honor.
All right. So you go 1, 2, 3, 5, 4.
I had split it up because of how the
You got
sentence-
these numbers all like, sort of, you've riverized this
I don't know if that's
plea
true,
form.
that's rivers.
And you turned it, you got the counts numbered one way up at the top, but then you numbered them a different way in the form. You riverized it, you see?
Tried to make it just floating down as
So
far
it's
as the
hard for me to
sentences go.
figure out what you're doing here, but I finally do after I get out my, what's that stone, that Rosetta Stone, and figure out this plea. So I want to make sure Mr. Truman, you know, he understands it too. So that's what you're pleading to, correct, Mr. Truman?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. And count 1.
Judge, we are waiting to impose sentence on December 30th. The state, I believe, also.
Oh, yeah.
stipulates to that.
All right. Okay.
Yes.
We'll,
So
we'll
we can
impose
do that
sentence
that
on
morning.
December 30th then.
Thank you, Judge.
Okay, thank you. Okay, who's next?
Mr. Wesson.
All right, this is 24 CF 783, 23 CF 1608, and 23 CF 2429, State versus Daniel Wesson. All right?
Yes, Your Honor, we're here today for sentencing,
Okay.
and I did file with the court a motion for downward departure. I did send the court a sentencing letter, and I have now received a sentencing letter from the state. I would like to take some testimony from 2 witnesses.
All right.
First would be Mr. Daniel Wesson.
All right, Mr. Wesson, would you please raise your right hand to be sworn? You swear the testimony you give for his court's true, so help you God.
Yes, sir.
Thank you.
Would you please state your name for the record?
Daniel Reed Wesson?
Are you asking the court for a downward departure?
Yes.
What is one of the reasons?
For medical?
Did you have surgery as a result of this case?
Yes, I did.
Okay, I'm going to show you something, and I'm going to ask you if you recognize it.
Yes.
All right, what is it?
It's the medical records?
Okay, is this from your case?
Yes, ma'am.
All right. Your Honor, the state had previously stipulated to these medical records.
I don't object to authenticity, I do object to admissibility. It's all hearsay.
There is case law that talks about you can't have hearsay.
You're objecting to the you're not objecting to the authenticity, but you're objecting to the relevancy. Is that what you said?
Relevancy, admissibility, it's all hearsay. We would need a medical doctor to explain what those documents are.
Records that are certified can come in.
And even, Your Honor, as far as the relevance is concerned, I have an objection on that ground as well, because all those medical records refer to the initial surgery that took place in March 27th at the time of the incident. And about 100 pages of that have to do with a report of some medical complications of August 30th. They were resolved by the 3rd of September. And now we're in November. I don't believe they're relevant. And they're hearsay.
Your Honor, hearsay is allowed at sentencing. Medical records are allowed to be entered. And, Your Honor, there is case law which I cited.
I'm gonna let it in.
Yeah.
Thank you. I mean, it's all about involving medical issues that have been arisen from him being shot.
Yes, sir.
Okay. It's nothing before that, though, right?
Correct.
Okay.
Your Honor, the state, okay, so, sir, did the doctors, you were shot in this case, correct?
Yes, ma'am.
And did the doctors remove the bullet?
Yes.
Okay. Was there trauma to your organs?
Yes, there was.
Was there,
They had to remove a large amount of my intestines and part of my bowel.
okay. When the procedure was over, did they sew you up or did you have an open wound?
It was an open wound.
Okay. Do you know why that was?
To give time for it to heal.
Okay. Did they have to reroute some of your bodily functions?
Yes, ma'am.
All right. Does a Hartman pouch sound familiar?
Yes, ma'am.
Currently, how do excrements leave your body?
They leave out of my intestines straight into a pouch.
Okay. Is that called a colostomy bag?
Yes, ma'am.
Was that supposed to be a temporary?
Very temporary.
All right. Is it still there?
Yes, ma'am.
Where is the bag?
It's right here on my side.
Which side is
Right
that?
here.
Your right side? Okay. So do you still have an opening in your body right there?
Yes.
Okay. Is that subject to infection?
Yes, ma'am.
What, if anything else, were you supposed to have done medically?
They're supposed to reroute it back to my large intestines.
Objection, hearsay, Your Honor.
Did that happen?
No, ma'am.
Let me rule. Overrule.
Did that happen?
No, ma'am.
Okay. Why not?
Because I was taken immediately to the jail.
Okay. Are you, as we can see, you're still wearing the jail outfit. Let me ask you about the jail. Do you consider the jail clean?
No, ma'am.
Have you ever seen any mold at the jail?
Lots of it.
In your opinion, is the jail clean and sanitary environment?
No, ma'am.
Have you ever had problems keeping your open area clean?
Yes, ma'am.
Has medical been consistent on getting you a clean bag every day?
No, ma'am.
Okay. Have you had any medical problems since that surgery requiring you to be, taken to the hospital?
Yes.
Okay. Did you suffer before you went?
Yes, for a whole week.
Okay. And you ultimately went back to the hospital, correct?
Yes, ma'am.
Does August 30th sound correct?
Yes, ma'am.
And what did you have to have done?
They had to do, they called it a Hail Mary. They had to pump fluids into me, hoping that it would pass, the obstruction would pass, or I had to have emergency surgery.
Okay. And what was your condition classified at that time?
A level 6 septic with 30% chance of survival.
Okay. Are you subject to that happening again?
Yes, ma'am.
Objection, Your Honor, hearsay, he's not, that information is
Sustain
not.
on that. That's speculation.
Is there anything else in the jail that you believe causes problems for your condition?
Not getting proper diet, things like that.
So are you asking the court for a downward departure to allow for the additional surgery that's necessary?
Yes, ma'am.
Are you asking the court for downward departure on any other grounds?
For PTSD, for mental health.
Okay. Have you ever been diagnosed with PTSD?
Yes, ma'am.
All right. Any other mental health conditions?
Manic depressant and bipolar syndrome.
Let me talk to you about the PTSD. Have you ever suffered any type of physical abuse?
Yes.
Okay. By whom?
My stepfather and multiple police officers.
Okay. What type of job did your stepfather have?
He was a police officer for Christian Police Department.
And
Objection, Your Honor. He's speculating. There is no psychological report here to provide information on the whatever.
Sustain.
did you ever I'm sorry, what type of job was it that your stepfather had?
He was a police officer for Christian Police Department.
Okay. Did your stepfather just physically abuse you, or was there any other types of abuse?
Sexual, mental, and physical abuse.
Did your stepfather ever use any drugs to subdue you during the sexual abuse?
Yes, ma'am.
And have you suffered serious trauma as a result of that?
Yes, ma'am.
Have you ever had any violent encounters with law enforcement?
Many a times.
Okay. I want to ask you about Santa Rosa County in particular. Was there an incident involving physical violence by police there?
Yes, I was pulled out of a truck and beat to almost death.
And the state has objected, and the court has sustained the issue of PTSD. So we just have to go along without that. Have you been able to get treatment for your mental health needs in the past?
No, I have not, due to finances.
Okay. And is there something in your mind that triggers you when you have encounters with law enforcement?
Usually loud noises, being told the same thing I got told by my stepfather, that I'm gonna do this the easy way or the hard way, things of that nature.
Okay. Is there any other reason why you're asking for a downward departure today?
My wife is, or fiance, Jocelyn Wesson, is needing a full hysterectomy done, and I want to be there to take care of her financially.
And that's all the questions I have at this time for Mr. Wesson. The state's going to have
Yes,
questions.
Your Honor, I do have a couple of questions. Mr. Wesson, you were taken to the hospital on August 30th, correct?
Yes, ma'am.
And the diagnosis was possible small bowel obstruction, correct?
Yes, ma'am.
And you were discharged a day later, day and a half later, correct?
No, it was 3 days, ma'am.
The discharge document that the defense has introduced show a discharge date of 9/1, Your Honor. And on page 18 of that report that was shared with me in discovery said that you were doing pretty well, correct?
Once I was able to.
Yes or no, sir?
Yes.
They said you were doing well. And also, on that day, when they discharged you, said that the small bowel obstruction was resolved, correct?
Yes, ma'am.
And also,
Hang
the
on,
doctors
Miss
prescribed.
Leon, hang on one second. Mr. Gibbs,
Yes, Your Honor.
you're interfering with Miss Leon's cross-examination. Y'all have to talk out there or something, okay? Go ahead, Miss Leon.
Yes. And the doctor on page 18 of that report states that you should be placed on a regular diet, nothing special, correct? That's what the documents introduced, correct?
A diet with somebody with a colostomy bag.
Right. Now, you had a midline incision, and on page 21 of that report, it shows that it was well-healed midline incision that shows no hernia. Is that right?
As far as I know, yes.
Very good. Now, the colostomy bag, still on page 21 of that report, said that it was pink and healthy. Is that correct?
Yes.
And the outcome of the chief complaint for which you were taken to the hospital was stabilized. It says on page 31 of that report.
Yes. They removed the blockage.
And your condition was stable, correct?
Yes, ma'am.
And on page 23, the doctor said that you could return to work. And they gave you medical clearance, correct?
Not to work, but yes, I can't work.
It says on page 33, and it also says on page 36 that the patient doesn't appear in any distress. You were doing well, correct?
Yes.
And the lab reports, according to the doctors, were not concerning, correct?
I don't know, ma'am. I don't get.
And the problem was resolved.
Yes.
Thank you. Yes.
Do you still have to have the surgery to remove the colostomy bag?
Yes, ma'am.
Are you still subject to infections
Yes,
with
ma'am.
having a colostomy bag?
Every day. My skin literally eats off my body every day.
Nothing further.
All right, thank you, sir. Next
I
one.
do have, Your Honor, I'm sorry, I wasn't done with the crossing. He announced other grounds for downward departure, so I was gonna question him on that.
Okay.
So basically, you're alleging the ground that the capacity of the defendant to appreciate the criminal nature of the conduct or to conform that conduct to the requirements of the law was substantially impaired. Mr. Wesson, did you hear law enforcement when they came and knocked on the door that day? You heard them, right?
Yeah, when they were beating on it, yes.
Yeah. And you also knew that they were there to arrest you for the violation of probation, correct?
I didn't know what they were there for, ma'am.
You knew that they were there to arrest you, correct?
No, ma'am, they didn't specify my name at first.
You knew that probation has placed you in violation, right? You knew that.
I knew I had a violation, ma'am.
Right. You knew that when they came there and your wife got out of the shed where you were, you heard them very clearly that they were there and they asked you to get out,
No, ma'am.
correct?
No, they did not, ma'am.
During trial, this court was able to review the body camera, and it was pretty evident that the law enforcement officers were clearly asking for your name and to come out. Is that right?
Well, after they removed my fiance, yes.
And you refused to get out, correct? Because that's why you used the rope to control the door,
I
correct?
barricaded myself because they gave me a threat, ma'am.
And now that took a few minutes to accomplish, correct?
No, ma'am.
To set the rope and then pull it?
Absolutely not.
No further questions, Your Honor.
Your Honor, I have another witness.
Okay, thank you, sir. All right, call your next witness.
Jocelyn Wesson.
Would you please remain standing, raise your right hand and be sworn? Thank you.
Would you please state your name for the record?
Jocelyn Renee Wesson.
Ms. Wesson, do you know Daniel Wesson?
Yes.
How do you know him?
He is my fiance, so my ex-husband.
What, if anything, would you like to say to the court today for the sentencing?
That he doesn't deserve the time that they're trying to give him, and he's not the monster they're trying to make him out to be. And he's always been a good husband and dad. And kind of just lost his way for a little bit. But he's on the right track now, and that's what he was trying to do.
I don't have any questions, Your Honor.
Thank you. Thank you. Anything else?
I don't have any witnesses.
Just closing remarks, Your
All
Honor.
right, do y'all have a score sheet?
Yes, Your Honor.
Can't seem to locate it, mine. All right. Go ahead.
Your Honor, Mr. Wesson is seeking downward departure under several grounds. One is Florida Statute 921.0262C, the capacity of the defendant to appreciate the criminal nature and conduct or to conform that conduct to the requirements of the law was substantially impaired. As he had mentioned earlier, we can do this the easy way or the hard way is something he heard right before his stepfather would abuse him, and his stepfather was a law enforcement officer. That, again, was something that he heard on this very day. Also, under 921.0262D, the defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, or for treatment for a physical disability, and the defendant is amenable to treatment. We've heard testimony today that he, as a result of being shot, he does suffer from a physical disability, the disability of his normal bodily functions. He has an open hole in his side. He needs a reversal of the procedure that would allow to reroute the bowels and the process to where he would no longer need the colostomy bag because his intestines are now functioning, so his intestines can function properly. As a result of not having it, he's subject to infections. He mentioned septic, blockages, and even death. There's also the testimony that we heard that he suffered years of physical, emotional, and sexual abuse by his law enforcement stepfather. He also testified to violence at the hands of Santa Rosa law enforcement officers. He mentioned mental illness. There is legal and factual basis to depart from the minimum guidelines. He's asking the court to consider a downward departure, whether the court imposes a suspended sentence or a straight-out downward departure to where he can see about getting the additional surgery to get his body back to as normal as it can be. Mr. Wesson will pay for his decision that day for the rest of his life. He has a permanent reminder. That's all.
Yes, Your Honor. As this court is aware, this defendant was found guilty by a jury for aggravated assault on law enforcement officer. The state recommends the following sentence. In 24 CF 783, adjudication of guilt, 15 years in the Department of Corrections with 3 years minimum mandatory, all fines and statutory costs. For the two VOP cases, 23 CF 1608, 23 CF 2429, the state asks for an adjudication of guilt, revoke and terminate probation, 15 years in the Department of Corrections concurrent, court costs, and cost of prosecution. Your Honor, as the court is aware, downward departure is a two-step process. First, there has to be a legal basis for a downward departure, and even when there may be a legal basis, then the court needs to assess whether it should depart. Is the state's argument that today the defendant has provided no legal basis for a downward departure? As the medical records show and the defendants testify, he does not appear, he's not disabled, he doesn't have any disability. The reversal of surgery is not a necessary procedure, and therefore he's not entitled to that. Additionally, the other basis that he advances, that he precisely the capacity of the defendant to appreciate the criminal nature of the conduct or to conform that conduct to requirements of the law was substantially impaired. The state disagrees with that statement and with that argument, given if we only look at the criminal records of this defendant. There is no way that he didn't know what he was doing, and he didn't know that he had to comply with the orders. And this court has seen the videos and the approach the law enforcement had when they went to serve the warrant. Your Honor, this crime threatens the very fabric of our society and undermines the authorities of those sworn to protect us. He knew precisely why the law enforcement was present at the time, and his refusal to comply with their lawful orders, followed by the reckless act of lunging at Sergeant Robinson with a knife, exemplifies a conscious choice that this defendant made to escalate a situation that could have otherwise been resolved peacefully. We wouldn't be here, Your Honor, had he complied with the order to step out of the shed. These defendants' actions were not impulsive. They were premeditated. It took him a while to secure the door and impede law enforcement from lawfully entering the shed. His criminal history. His criminal history is full of violent crimes. He's been convicted twice of battery, once of aggravated assault by threat with a deadly weapon, and those were not against law enforcement officers. These were against civilians, Your Honor. 21 misdemeanors, another aggravated assault by threat with a deadly weapon, willful violation of pretrial release, possession of short barrel rifle by convicted felon, tampering with a witness, that was a first-degree felony, child abuse without causing great bodily harm, felony battery by causing great bodily harm, child neglect, possession of controlled substance, 2 counts, felony battery, aggravated assault by threat with a deadly weapon, again, possession of a controlled substance, and felony battery. According to the guidelines, Florida guidelines, minimum presumptive sentence that this defendant should serve is 84 months in the OC. However, there is also a 3-year minimum mandatory, given the fact that he committed aggravated assault on law enforcement officer, and that there cannot be a downward departure on that. The medical records show exactly that he is not in any particular risk, and he can be provided necessary care. The state respectfully asks the court to impose a sentence that accurately reflects the seriousness of the defendant's actions, the fear instilled in Sergeant Robinson and his family, and the need to protect our community from further harm. A sentence greater than the minimum guidelines is not just warranted, it is imperative, Your Honor. Therefore, the state asks that the defendant be sentenced to 15 years in the Department of Corrections with 3 years minimum mandatory.
As I read the score sheet range, it's 84 months to 36 years, correct?
Yes, Your Honor.
Courts reviewed the pre-sentence investigation, the letters, sentencing memos from the public defender and from the state. The court is very respectful of the jury's verdict. The court saw the evidence of the efforts the officers made to try to get Mr. Wesson to come out. Mr. Wesson, you have an extensive criminal history, and the court's considered the allegations of abuse and all, and but in the pre-sentence investigation, he says you were offered many opportunities for counseling and therapy, and you never took advantage of any of those opportunities. The court could, the way I look at it, to give you 36 years in prison. What the court's going to do is find you're a violent felony offender of special concern, and 24 CF 783 adjudicate your guilt. Guilty, sentence you to 15 years, Department of Corrections, 3-year minimum mandatory, all fines and statutory costs. And 23 CF 1608 adjudicate you guilty. Revoke and terminate probation, 15 years, Department of Corrections, concurrent, statutory costs of prosecution. 23 CF 2429 adjudicate you guilty, revoke and terminate, 15 years, Department of Corrections, concurrent statutory costs of prosecution. I could have given you probably 45 years if I wanted, but I'm going with that based on your extensive record, and you could have killed the officer and you would be looking at probably the death penalty, and It's regretful that you got shot, but we watched the video cameras, and the officer did everything they could to just ask you to please come out, and you came out with a knife and tried to stab the officer. So the court tries to look for every advantage I can give to the defense, but, you know, I feel like instead of giving you 36 years, I'm giving you 15. So thank you.
Thank you.
Any monies on the violation to collection?
Yes.
If I may, earlier, we addressed Mr. Kenneth Wayne Jernigan on case number 23 CF 239, and the court reset that for the 7th at 9. I've spoken with Mr. Williams. May we request that that be set for 2 o'clock instead?
Ms. Barrett texted me.
All right.
Issue with getting the witnesses here for 9, so.
All right.
Thank you, Judge.
Okay.
Perfect. Your Honor, we're back on the record with Mr. Dennis Howard Brooks, 23 CF.
On that, Wesson, I forgot to say credit for time served. Thank you.
Thank you, Judge.
Who is this?
Your Honor, this is Mr. Dennis Howard Brooks, 24 CF 1374, 23 CF 1000. Judge, he is going to enter an admission to the violation of probation in 23 CF 1000. In exchange for that, I believe the state is going to dismiss the charges in 24 CF 1374. However, we haven't reached a sentencing agreement on the VOP. We'd like to proceed to sentencing and stand her immediately if we could. He doesn't score presumptive prison sentence, if you would see
All right.
today's date.
Mr. Brooks, would you please raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God.
Yes, sir.
Okay.
Just put today's date. Ms. Turner, I'll need your signature.
Oh, yes, sir.
Nope, I got it. She included. Lint roller.
All right, this is State of Florida versus Dennis Howard Brooks, 23 CF 1000, 24 CF 1374, 23 CF, 1000. You want to admit, Mr. Brooks, that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, I do.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs did for you on your
Very.
case? You're not?
Very.
Oh, okay.
Very.
Court finds the admission freely and voluntarily entered. Court accepts it. And this is a violation of probation, and the state's going to dismiss 24 CF 1374, correct?
That's correct.
Okay. And what is the sentence request of the defense? I mean, what is?
Your Honor, we were hoping to, he's got about, today he should have about 193 days worth of credit on that VOP case number. We're essentially asking for that time served. It's a little over 6 months. His family is here. The alleged victim, Ms. Melissa Brooks, is present. She is actually the alleged victim on both cases. If the court would like to hear from her, I'm happy to call her. We had provided a sworn statement where she was requesting the new charges be dropped. I believe the family wants him home so that he can get into the treatment and counseling that he didn't do while he was on probation, and start making those positive changes in his life and with his family.
What does the state say?
Judge, the state is asking for an 1129 jail sentence for Mr. Brooks. He was placed on probation December 7th of 2023 for 2 years. He violated, it's a technical violation, for tampering with the urine specimen in March of 2024, so just 4 months after going on probation. Then there was a positive drug test as well for, I believe, meth and amphetamines and methamphetamines. The victim in the case has been vocal about Mr. Brooks needing a mental health evaluation and any recommended treatment, which was also court-ordered when he was on probation, and he did not do anything to that effect. So with the technical violation, he scores 41.2 points, which is not a presumptive DOC sentence, but for those reasons, the state is asking for an 1129 jail to revoke and terminate.
How much time has he served?
Judge, my estimate, he's got about 193 days today, which is over 6 months, which is 180 days. So that's why we're asking essentially for 6 months credit for time served.
Well, he hadn't done anything to deserve that, so 11 months, 29 days, county jail, credit for time served, adjudicated guilty.
Understood.
Thank you.
We try.
No probation to follow.
Thank you,
Revoke
Judge.
and terminate, I guess.
Thank you, Judge.
Okay?
Thank you.
Good luck.
Outstanding monies to collections, Your Honor.
Yes. Okay.
Your Honor, Tim Gibbs on behalf of Mr. John Fleming. Judge, we're here on 23 CF 1634, 22 CF 2205. I believe we have an agreement.
Mr. Fleming, would you please raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God?
Yes, sir.
Thank you.
Just 1 second so he can review and sign, Judge. So,
All right, so it looks like we got 4 trials. Is that right? 4?
I have 2, Your Honor. So I think Ms. Bergman has the other 2.
Bergman has 2, and then Ms. Leone has 2,
Yeah.
so.
2 and 2 is 4, right?
Yeah, I'm sure about my own, Judge. I didn't want to speak.
sign right there for me, please, if this is what you'd like to do. And today's date, please. Today's November 4th. If I may approach, Your Honor.
All right. This is State of Florida versus John Fleming, 22 CF 2205 and 23 CF 1634. You want to admit that you violated probation, Mr. Fleming? Did you read and sign this plea and sentencing agreement form? Did you read and sign this form?
Yes, sir.
That it explains your rights that you're waiving by entering this admission? You understand that?
Yes, sir.
And anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs did for you on your case?
Yes, sir.
Court finds the admissions freely and voluntarily entered. Court accepts it. State's going to dismiss 23 CF 1634, correct?
Yes, sir.
Okay. And in 22 CF 2205, you're adjudicated guilty, sentenced to 9 months Okaloosa County Jail, credit for time served. Is it a $100 cost of prosecution?
Yes, Your Honor.
$150 PD fee due within 180 days or to judgment.
And revoke and terminate, Your Honor.
Revoke and terminate. So how many days you got credit?
He's been in since July of last year, Judge.
Oh, well, you're probably getting out unless there's
Yes, sir.
some hole, right?
So there's
Yes, sir.
there's only other one case number, Judge, 23 CF 1813. That's with Ms. Barrickman. We're going to request to continue that to 12/30 to try to get it resolved otherwise, and he has a bond on that he should be able to make, so we don't need to adjust that either.
Okay. All right. Well, Okay, good.
Thank you, Judge.
Thank you so much.
All right, good luck. Give me a call when you get out, okay? And I believe, Judge, that covers all of my business.
All right, good.
Thank you.
We have anything this afternoon?
Your
No?
Honor, that I know of.
All right.
Yeah. It's like last time with you. Remember you
Yeah, that's
brought
right, I
two,
had one.
and I